through emails. I'm Deta, and today I'm with. I'm also. I also have Dr. Sharif Alisa joining the class, who's
Good morning.
who also co-teach in the contract testing class in Universitas Sumatera Utara. So on behalf of the faculty, I would like to thank you for participating in our class, for saying yes to provide your knowledge and then also your expertise in specifically in common law and Singaporean contract law. So it's a great honor for us, and I really hope that we can have a fruitful class and discussion for the next three sessions, I guess, which will be all compiled today and the class on the 21st, I believe. So let me elaborate a little bit about the class itself. So this is a contract drafting class. So in Universitas Sumatera Utara, all students take this class. It is a mandatory class, even though that they are going to do criminal law or economic law or international law. Contract drafting class is a compulsory class. So it means that now that most of them have already started their specialization, they still need to do a contract drafting class. So I think having a common law perspective would definitely equip them, regardless to their specification. So will you have any presentation for today, like a slides that you want to share, so that maybe I can give you the access for presentation?
Yes, that would be very helpful. I do have PowerPoint slides I'd like to share on my screen.
Okay. So let me change it. Oh, okay. I think you already have the access. So the way that we're gonna do this, because considering that some of the students here, like they don't have the same English proficiency level. So if you don't mind, I will maybe occasionally check with the class to what extent that they can follow your delivery. So just in case, I will probably elaborate and highlight a few important points in Bahasa, just to make sure that they follow the class. So without further ado, Prof. Liu, the Zoom floor is yours. Let's have a fruitful discussion. Thank you.
So yes, thank you very much, Dr. Detania, and everyone here. I would welcome questions at any point, actually, if I'm unclear, or if anyone would like anything repeated or explained. I'm happy to hear that directly, or of course through your wonderful lecturers. Actually, just one moment. I'm going to turn on the light so I have a bit better lighting here. Give me one moment. Yes, hopefully that's a little bit better. I realize my face is a bit blue from the reflection. Not sure. Anyway, so I'm really glad to be here. It's an honor to be addressing the class on this. I will try to give some generally useful perspectives on contract drafting and risk management from a common law perspective. I'm going to be giving this in quite a broad overview fashion because you are not training to be common lawyers, but maybe if you do become corporate lawyers, or if you were to be litigation lawyers who end up doing disputes which have a cross-border element, you might encounter negotiating parties or counterparties who are on the other side, and are from a common law jurisdiction. So I think it can be helpful to know all this, and you might have contracts that end up being governed by common law, domestic law, who knows? So that's what I'm going to try to give you in terms of useful takeaways. So today's class is going to have, yes, 7 parts. Sounds like a lot of parts. We'll see how it goes. But I'm going to start with an overview of the attitude towards contracting in the common law, because it's not necessarily the same as in civil law jurisdictions such as Indonesia. And after that, I'm going to zoom in on a few particular kinds of clauses that tend to be incorporated into commercial contracts. Sorry, just a moment. I think there might be a bit of sound coming from someone's. Yeah, I'm just going to directly mute if that's okay. Yeah, sorry, I think someone may have accidentally turned their
Sorry
sound.
about that, Professor. Yeah, it might be someone
No
just.
worries. No worries, it happens. So I'm going to then cover a few of these specific types of clauses that parties often seek to introduce with certain commercial objectives in mind, often as a way of managing risk before it happens. So starting from the concept of freedom of contract, in common law jurisdictions, we tend to have quite an extreme view of freedom of contract as a starting point. This is how Professor Stephen A. Smith has summarized this sort of radical idea of freedom of contract. He doesn't necessarily agree with the idea, but I think it's a good statement of the idea. It is, I quote, the notion that the content of a contractual obligation is a matter for the parties, not the law. What does that mean? Well, of course, it doesn't mean that there is no legal position or that it's impossible to say what the law is. Rather, what this quote is getting at, what it means is that the common law takes it that primarily whatever is going to govern and bind the parties to a contract is something for them to discuss and agree on. And whatever they've agreed on, the law, the courts in particular, will be slow to interfere with, to add to or subtract from. So that's the basic overall attitude of the common law. It has some limits. There are, of course, default rules, because what if the parties to a particular contract don't negotiate on a particular question? There has to be some kind of default rule that steps in. So, for example, if we have a contract that does not state the time for performance, then the law does step in to interpret that as, well, performance during a reasonable time, and the court will determine what the reasonable time would be. So that's an example of a default rule, something that applies if the parties haven't provided anything otherwise. There are also restraining rules. So rules that, I mean, we don't necessarily use these terms in the common law. This is my label for it. And here I refer to rules that can even override parties' agreement. So later on today, I'll talk about something called the rule against penalties, which basically places limits on the amount of damages that someone can be required to pay in what we call a liquidated damages clause. And that's a kind of rule that applies even if the parties have agreed otherwise. So freedom of contract is the starting point, but there are limits. Now, one of the things that freedom of contract implies is also that when you have a written contract, and parties have actually boiled their agreement down to writing, they put into words on the page, on the screen, what their bargain is, then there are rules that make it pretty hard for one party or the other to seek to add to or subtract from that. But even though that's the starting point, the parties will often want to bargain for even more specific protections because they want even more certainty. They want, for example, to be assured that whatever is written on the page in whatever document they signed is going to be what they are bound by and nothing else. And that's where we get the first three kinds of clauses I'm going to talk about today. These are all three of them clauses that are basically meant to keep out stuff that might otherwise try to enter the written contract. The first is an entire agreement clause, the second is called a non-reliance clause, and the third is called a no oral modification clause. And I'm going to cover these three together, or well, one after the other, because they have that in common. These three are clauses that try to keep the parties' bargain restricted to what is written in the contractual document. So starting with entire agreement clauses, this is a clause that says that the whole agreement of the parties, the whole contract, is to be found only in the written document, the written contract, we might say loosely. And the point of this is to then make it really hard for a party to say, hey, even though something is not written in the contract, it is still, or rather in the contractual document, it is still part of our contract. You promised me something when we were talking, or you promised me something in a text message or email. And even though later we concluded this document, that other promise you made to me still is part of our contract. An entire agreement clause is there to help a party say, hey, no, you can't do that. Our clause, our entire agreement clause says that there's nothing outside of this written document. Now, there aren't any magic words that have to be used. It's a matter of contractual interpretation. So if it goes to court, if there's subsequently a dispute, it will be an exercise in the common law court interpreting the contract to decide whether the parties intended objectively for this clause to be an entire agreement clause. Here's an example of wording that you might see. This is from an actual case. This agreement embodies the entire understanding of the parties, and there are no provisions, terms, conditions, or obligations, oral or written, expressed or implied, other than those contained herein. This is a very typical example of the kind of wording that you might see included in a contract to try to keep out anything else. So any questions about these clauses or what they try to achieve before I move on?
Can please allow me maybe just to elaborate in Bahasa if you don't mind,
Certainly.
Prof. Liu.
Thank you very much.
To get the context of the class. Jadi Prof. Liu ini beliau menjelaskan ya hal apa namanya basic dari kontrak common law. Beliau entry point-nya itu tadi adalah tentang kebebasan berkontrak ya. Kita juga di dalam KUH Perdata ada konsep kebebasan berkontrak. Tetapi kebebasan berkontrak yang dimaknai dalam dunia common law itu lebih agak berbeda gitu ya. Berbedanya adalah bahwa kalau kita memiliki berbagai ketentuan peraturan perundang-undangan, kita punya KUH Perdata, ada norma yang memaksa, ada norma yang mengatur gitu ya. Kalau kita punya KUH Perdata, kalau di common law ada juga konsep default rules gitu ya, kurang lebih seperti itu. Default rules itu tapi sayangnya dia sedikit berbeda karena tidak semua negara itu memiliki KUH Perdata yang memuat tentang norma-norma tentang ketentuan umum tentang kontrak gitu ya. Jadi batasan-batasan tentang kebebasan berkontrak itu di tiap negara bisa bervariasi gitu ya. Intinya seperti itu. Kemudian tadi Prof. Liu juga menjelaskan tentang apa namanya tentang apa sih yang dimaknai sebagai kontrak gitu ya. Jadi kalau dalam konsep common law itu kontrak itu dipandang lebih kaku dan lebih kuat gitu ya. Saya ada tulis di chatroom, Anda bisa lihat semua gitu ya. Jadi kalau kita, I will probably elaborate with you on this, Prof. Liu, because in Indonesia we apply the principles of good faith, ya. So we don't apply parallel evidence rule, but we apply the principles of good faith. Jadi apa namanya kontrak itu dipandang lebih kaku. Jadi peristiwa-peristiwa apapun di luar kontrak yang sudah ditandatangani itu tidak bisa ditafsirkan sebagai bagian daripada kontrak gitu ya. Nah, ini juga akan berkaitan juga dengan sampai sejauh apa hakim bisa menafsirkan kontrak. Apakah dia bisa keluar dari bahasa-bahasa kontrak gitu. Nah, kalau di dunia common law mereka nggak punya prinsip good faith ini atau itikat baik ini. Jadi mereka kontrak itu lebih kaku. Nah, meskipun ada nanti keberlakuan parallel evidence rule namanya, hal-hal di mana janji-janji yang mungkin tidak seluruhnya terekspresikan di dalam kontrak itu bisa mengikat ya. Nah, itu dia. Nah, jadi itu kenapa itulah kenapa diperlukan membuat klausula-klausula di dalam kontrak kebutuhan gitu ya. Nah, para pihak maunya apa nih gitu ya? Apakah misalnya mau mengunci kontraknya atau justru membuka peluang gitu ya? Hal-hal yang mungkin apa namanya disepakati tetapi tidak terekspresikan dalam kontrak. Nah, itu akan menentukan klausula-klausula yang dibutuhkan. Makanya tadi Prof. Liu menjelaskan tuh contoh-contoh klausulanya dan ini juga yang kita lihat di layar gitu ya. Mungkin contoh klausula yang berusaha mengunci supaya tidak ada hal-hal di luar yang tertulis itu yang bisa mengganggu gugat ya yang sudah disepakati dalam kontrak. Thank you, Prof. Liu. I hope they can get the whole context. Dan Prof. Liu juga bertanya kalau ada pertanyaan, silakan boleh angkat tangan, raise hand, atau boleh juga sementara nanti tulis di chat room ya. Boleh dalam bahasa Indonesia, kalau takut salah nggak apa-apa. Nanti saya Bu dan Bu Syarifah, Bu Ipeh bantu ya. Please, Prof. Liu, please move forward.
Thank you very much. And just to clarify something, I think it's very interesting that your lecturer, Dr. Detania, mentioned how in your law you have the principle of good faith and you don't have the parallel evidence rule. And that's a really significant difference, I think, because in common law, for better or for worse, we have a very oppositional adversarial assumption that I am negotiating with you for a contract. We are, in a sense, opposed to each other. I will try to push for as much as I can get. You will try to push for as much as you can get. And if one of us fails to put in the clauses that are helpful to us, that's too bad. It's just winner takes all. You're stronger, you're more persuasive, you are more knowledgeable, you get the favorable clauses in, you'll win, basically. We don't have this idea that the parties should be working together in good faith. We don't have this idea that the contract contains an obligation of good faith either, unless the parties negotiate for it. So that's a kind of clause that I'm not going to cover today. But it does exist. Sometimes parties do choose to actually agree that they are going to perform and interpret their obligations in good faith. And if they agree to that, then a common law court will give effect to it. But if they don't agree to that, then there is no obligation of good faith between the parties. Right, so and as earlier alluded to, we do have the parole evidence rule, which generally keeps the obligations to those embodied in the contract. Entire agreement clauses are there to sort of make the wall even more solid and even higher, because once you have the entire agreement clause, then there's something right there in the contract saying that there's nothing outside of it. And that's why parties bother to try to include it. So this is sometimes useful. It makes it, as I said, harder to argue that there are additional terms. And because of that, it increases certainty. If you don't see it written down, then it's basically not there. But there are some limitations to the usefulness of an entire agreement clause. And there are two main limitations to their usefulness. The first is that it does not necessarily prevent terms from being implied into the contract. And I'll explain what that means in a moment. It also usually doesn't prevent claims for misrepresentation or negligent misstatement, which I'll also explain shortly. So implying a term means that even though a term is not written down, it's not expressly stated, it can be kind of read in to the contract. And there are three kinds of ways that one can imply terms into a contract. It is actually quite a complicated topic in common law, contract law. So I'll just cover it at a simple level as I can. There are terms implied by law. Basically, that means a court, because in common law, the judges also can make law. A court has held that this term applies to every contract or to every contract of this type. Or maybe not a court, but a court can do it. But also, of course, if the legislature, if in our case, Parliament has passed a law saying that this term will apply to all contracts, then that's also going to be a term implied by law. There are also terms implied by usage or custom. That is when within a particular industry, let's say within the shipping industry or within the construction industry, there are these terms that everyone in that industry just accepts as being part of their contracts. It's like it's as terms as like a custom that is so common and long-standing that you don't need to write it down, but everyone kind of knows it applies. That's another type of implied term. And then finally, there are terms implied in fact. And these are terms which are implied because in a particular contract, in this specific contract, this term would be needed in order for the contract to be workable. Meaning, if that term was not implicitly part of the contract, then the whole contract would make no sense or be impossible to perform. Another way to put it is that an objective bystander reading the contract and looking at the interactions between the parties would consider it obvious to be part of that, or well, it's a bit more complicated than that. But basically, these are three ways that terms can be implied into a contract. It's actually quite hard. It's not a low threshold at all. It's very difficult to persuade a common law court that there is an implied term usually, and so this is not very. It's not easily done, but it is done sometimes. And an entire agreement clause will not necessarily prevent terms from being implied. The logic behind that is that at least some of these types of implied terms are thought to be already there inside the contract, just unexpressed. So if it is intrinsic, meaning, so let's say it's a term implied in fact, or a term implied by law, that is thought to be sort of already in the contract, even though it's not expressed. But then there are also thought to be some terms that are extrinsic to the contract, like terms implied by custom or usage. It's quite complicated and we can't go into it fully, but basically the long and short of it is that entire agreement clauses might be able to prevent some implied terms from being implied into the contract, but it doesn't necessarily keep out all implied terms. So the entire agreement clause is a very powerful weapon, but it's not perfect. It's not foolproof. Okay. Let's see. I think maybe I'll explain also how they don't prevent claims in misrepresentation, and then I'll pause for questions or for your lecturer to summarize. And then only then will I move on to the next type of clause. So the second limitation of an entire agreement clause is that it does not keep out misrepresentation or negligent misstatement claims. So these are different from breach of contract claims, right? A breach of contract claim is something like we have a contract and the contract says, I am going to sell you my mobile phone and I promise you my mobile phone has only been in use for 2 years, right? And then if my mobile phone has been in use for more than 2 years, it's older than 2 years, I have breached my contract, correct? I've promised you as part of the contract that my phone is only 2 years old. Misrepresentation is a different kind of claim. In a misrepresentation claim, you would not be saying that I was contractually obliged to give you a phone that was only 2 years old. Instead, you would be saying just that I lied to you about something. I told you something false, and that false statement caused you to enter into the contract and caused you to sustain some loss. So imagine that we signed the same contract. I say I'm going to sell you my cell phone, but there's nothing in that written contract or indeed even in our oral agreement that says I promise you the phone is no more than 2 years old. But let's say before that, before we even agreed on this sale, I had earlier told you, hey, my phone is only 2 years old. So that's a statement of fact. And it's a statement of fact that might have caused you to enter into the contract, even though it didn't form part of the contract. And so you might be able to sue me if my statement was false and misleading. So that kind of claim is not kept out. It's not barred or excluded by an entire agreement clause. Because if you were to make that kind of claim against me, you would not be trying to add anything into the contract. You're not trying to say that that our contract includes an obligation on my part to make sure the phone is only 2 years old. Instead, you'll be saying that, hey, outside of the contract, I lied to you. Okay, so entire agreement clauses don't deal with misrepresentation, and they don't necessarily prevent terms from being implied into the contract, but they are otherwise very powerful. Okay, so let me pause here for questions or for Dr. Detania to summarize if she wishes.
Yes, thank you, Prof. Liu. Jadi intinya Prof. Liu barusan menjelaskan bahwa ketika ada situasi ketika terjadi yang namanya misrepresentation, ya misrepresentation itu misalnya mencantumkan sesuatu hal dalam kontrak yang ternyata terbukti tidak benar atau ternyata dia berbohong, gitu ya. Jadi misalnya mungkin tentang kondisi barang gitu ya, tentang spesifikasi barang, contohnya misalnya ya kan. Nah intinya adalah kalau terjadi yang namanya misrepresentation ya kan, atau misalnya false statement itu ternyata ketika kita bicara memasukkan klausula entire agreement tadi kan ini kan tujuannya adalah untuk mencegah adanya implied terms gitu ya, hal-hal lain di luar kontrak untuk ikut ditafsirkan gitu ya. Tapi kalau dia sudah berkaitan dengan penipuan, ya, bukan ya bisa dikatakan penipuan ya, atau hal-hal yang ternyata tidak benar gitu ya, klausula ini tidak apa namanya pada umumnya dia tidak mutlak berlaku gitu ya, dia tidak berlaku ya dalam hal terjadinya misrepresentation atau false statement. So Professor, my question would be, for now, would be how will that affect the validity of the contract if, let's say, there's an existing misrepresentation or false statement, Prof. Liu?
Thank you. So, misrepresentation can affect the contract in two ways. One is that when there's been a misrepresentation that has caused loss, the party may be entitled to claim damages. But to answer your question directly, in terms of how it affects the validity of the contract, misrepresentation can also be a basis for rescinding the contract. So if you can show that you were induced by misrepresentation to enter into the contract, and you would not have entered into the contract without the misrepresentation, then that can be a basis to rescind or to nullify or vitiate, or their various terms, basically get out of the contract. And that's why it's very significant that the entire agreement clause will not prevent that kind of claim.
So does it mean that the clause itself, the entire agreement clause is how do you call it, like invalid or unexecutable?
So if there's been misrepresentation, if there's been misrepresentation that led a party to enter into the contract, then it's not just the entire agreement clause that would be that would be vulnerable to being rescinded. It will be the whole contract, including the entire agreement clause. And what that would do is make it. I may be misunderstanding the terms, but I think that would be more like invalidating it rather than making it unexecutable, because the whole contract, if a party chooses to use this ground to rescind the contract, then the whole contract is basically gone. It's not that there's still a contract, but it's not executable. So misrepresentation has very serious consequences for a contract.
Okay. Maybe I can elaborate on this with them. So, jadi kalau kita lihat di KUH Perdata itu, mungkin kita bisa lihat ke pasal 1321 ya dan seterusnya gitu ya, yang yang mengatur bagaimana kekuatan sebuah kontrak jika ada penipuan gitu ya, ada kesalahan ya, terus kemudian ada paksaan atau ancaman ya, terus kemudian berlaku lagi juga konsep penyalahgunaan keadaan gitu ya. Jadi ada kondisi-kondisi di mana kontrak itu dapat dibatalkan ya. Jadi sebenarnya ini konsep yang serupa ya. Nah, jadi intinya adalah ketika misalnya para pihak memasukkan klausula ini gitu ya, untuk istilahnya mengunci sebuah kontrak ya kan, tetapi kalau dia berkaitan dengan yang namanya presentation tadi ya, ketika ada informasi-informasi yang mungkin salah gitu ya, atau mungkin ditutup-tutupin gitu ya, tetapi ketika ternyata itu terungkap, itu bisa mengakibatkan kebatalan kontrak. Intinya seperti itu. Jadi kalau ada pertanyaan ya, tolong jangan sungkan ya, nanti langsung aja raise hand atau mungkin bisa tulis di chat room ya, nanti bisa kita bantu. Professor, please carry on.
Thank you very much. And of course, it's not that every misrepresentation could lead to the contract being rescinded. It has to be something that is significant enough that it is the reason why the party entered into a contract. If there was a misrepresentation and it caused some loss, but the other party would still have entered into the contract, then that will not necessarily allow the contract to be rescinded.
Oh, does it mean?
Yeah.
It has to be like, let's say, on the object, on the object of the contract or the consideration, perhaps?
Yes, or even if it is not the object of the contract, it has to be something that was important enough to the party receiving the misrepresentation that it induced them to enter into the contract.
Oke, so jadi menurut Prof. Liu, jadi ya konsep misrepresentation ini sebenarnya bisa berkaitan dengan apa saja, tetapi dia harus yang intinya adalah sifatnya mendasar gitu ya, yang kemudian bisa merugikan para pihak gitu. Jadi selain kemungkinan kebatalan kontrak, pihak yang dirugikan juga bisa mengajukan ganti rugi ya, tentunya damages ya terhadap pihak lain dalam kontrak. Professor, there's actually a question in the chat room. I will elaborate on it in English. So, Prof. Liu, Dinda asked a question. So, if in common law, if common law contracts does not apply the principles of good faith, so what would be the underlying basis on making a contract, Professor? That would be her question.
Thank you. Well, I would say that I think there are some ideas in common law that might overlap with some ideas of good faith, but it's a very sort of narrow kind. So there is still the idea that promises are meant to be performed. So pacta sunt servanda is still part of the common law. We just don't think of it as good faith. So I would say that is the underlying basis of the contract, that promises are meant to be performed. And once you have both parties making promises to each other, supported by, well, we call it consideration, but maybe I'll not complicate things. So basically, you have the promise from one party and the promise from the other party, and both parties have to live up to their promises. But they are only bound to do what they said they would do. And the law will be slow to step in to make them do more than what they have agreed. Yes, so I hope that answers the question.
Jadi Dinda, memang asas etikat baik itu kan sebenarnya turunnya dari hukum Prancis ya kan? Jadi tentunya kalau negara-negara common law ini, kalau kita lihat secara sistem ya mereka udah pasti nggak menganut itu, karena kalau kita lihat secara sejarah ya kan, Prancis menjajah Belanda, Belanda menjajah Indonesia, makanya kita juga mengadopsi etikat baik. Kalau di common law tidak gitu ya. Nah, jadi kalau kita di Prof. Liu menggunakan konsep asas pacta sunt servanda, ya kan, bahwa janji itu harus ditepati, ya kan, bahwa kontrak itu harus dihormati, harus ditepati, ya kita juga sama, kita juga menganut asas pacta sunt servanda, tetapi asas etikat baik itu bisa dikatakan menjadi semacam pembatas gitu ya, tetap terkait dengan keakakuan keberlakuan asas pacta sunt servanda. Tapi kalau di dalam dunia common law, ya kan, pacta sunt servanda atau disebut juga dengan sanctity of contract tuh, ya kan. Mereka ya karena nggak ada asas etikat baik ya, dia berlaku secara lebih kaku gitu. Nah, tapi bukan berarti kemudian tidak ada hal-hal yang dapat istilahnya menjadi pengecualian tuh misalnya. Ya kan, menjadi pengecualian. Nanti kalau kita nanti bahas lebih lanjut tuh ya nanti ya. Misalnya nanti Prof. Liu akan ada di dalam slide-nya tuh tentang klausula force majeure gitu ya. Force majeure itu bahasanya tuh bahasa Perancis kan, udah jelas. Jadi kalau karena dia bahasa Perancis, dia pasti dia lahirnya dari hukum Perancis tuh sebenarnya. Tapi kalau di dalam dunia common law, nanti sebenarnya mereka karena tidak ada asas etikat baik gitu ya, maka mereka juga otomatis nggak punya doktrin force majeure. Nanti makanya itu ada kebutuhan untuk memasukkan klausula force majeure berdasarkan kebebasan berkontrak. Jadi intinya sebenarnya itu gitu ya. Jadi kalau misalnya fokus dalam membuat perjanjian adalah bagaimana membuat perjanjian yang komprehensif, yang lengkap. Ya, jadi kalau kita ada yang kurang-kurang, ya kan, ada asas etikat baik, ada KUH Perdata, tapi kalau mereka ya kan mereka akan dipaksa untuk membuat kontrak yang selengkap mungkin gitu. Mereka akan dipaksa untuk memikirkan semua kemungkinan-kemungkinan ke depannya dan dimasukkan ke dalam kontrak. Jadi itu hal yang menurut saya fundamental gitu ya. Jadi fokus mereka tuh ke sana, membuat kontrak yang lengkap seperti itu. Prof. Liu, there's another question. There's another question from Farhan ya. Farhan mentioned about what we call the naturalia elements in a contract. Yeah, so in Indonesian contract literatures, some literatures would identify three elements of a contract, right? One of which is the element, if is the naturalia elements, which basically means default rules, yeah, default rules that can be put aside based on freedom of contract. Can you maybe explain more about how to what extent that this works under the common law system, and to what extent that this that the default rules cannot be set aside by freedom of contract, maybe?
Yes, thanks very much. I would say that in the common law, most default rules can be set aside. Most default rules. Some that cannot be would include things like the rules governing when a contract has been formed, which makes sense because those are the ingredients you need for there to be a contract in the first place. So you can't dispense with the ingredients of a contract by agreeing. You need those ingredients to come together before a contract even is created. But outside of that, most default rules can be displaced by parties' agreement. Of course, there are exceptions. One exception that I mentioned earlier, and we'll talk about later, is the rule against penalties. Another one would be illegality, which is a sort of public policy-based reason for not enforcing a contract. There are also rules based on our ideas of equity. So there are certain rules that a court will apply to relieve against unconscionable bargains, like where one party takes advantage of the other party's weakness in terms of not just being commercially weak, but let's say they are very old or illiterate, things like that. So there are many examples of rules that cannot be set aside even by agreement. But I would say that especially in the commercial context, the majority of default rules in common law can be displaced by agreement.
Does Singapore has like any sort of contract law codification in any way, Prof. Liu?
We have very limited. I think I would say we don't have codification, but we do have some legislative interventions. So we have acts that govern specific areas of contract law in very limited ways. So we have something called an Unfair Contract Terms Act, which I'll talk about later if there's time. But that has to do with specific things like excluding excluding liability. We have Consumer Protection Fair Trading Act, which in a very specific subset of cases gives protections to consumers. And that's how in Singapore the government has approached it. Like in many common law countries, there's no single contract law act, for instance, but there are lots of little acts that change little parts of the common law, but no codification of the whole thing.
Okay, I will provide your answer in bahasa. So, jadi pertanyaannya kan berkaitan sama unsur naturalia dalam kontrak ya, Farhan ya. Kalau yang saya pahami kan unsur naturalia itu adalah ketentuan-ketentuan hukum yang bersifat mengatur ya dalam kontrak. Jadi kalau dia bersifat mengatur, berarti ketentuan peraturan perundang-undangan itu bisa dikesampingkan dan diatur sendiri oleh para pihak. Jadi dia sifatnya nggak mutlak, ya kan? Itu dia sifatnya nggak mutlak. Nah, dalam konteks common law, ya kan, sebenarnya ya sama gitu ya, dengan kebebasan berkontrak, ya, ketentuan-ketentuan hukum yang bersifat mengatur itu bisa dikesampingkan dan diatur sendiri oleh para pihak, ya. Itu yang saya pahami ya dari pertanyaannya ya, konsep unsur natural ya. Jadi ada keleluasaan para pihak untuk mengatur sendiri. Tetapi kemudian tadi Prof. Liu menjelaskan lebih lanjut tentang pengecualiannya gitu ya, ketentuan-ketentuan hukum yang sifatnya memaksa, dia nggak bisa dikesampingkan. Nah, ketentuan-ketentuan hukum di sini nggak, kalau kita mungkin dalam konteks undang-undang, peraturan perundang-undangan gitu ya, bersifat memaksa, berarti dia nggak bisa dikesampingkan, jadi dia membatasi kebebasan berkontrak. Tetapi dalam konteks common law, bisa juga itu dia sumbernya adalah, kebanyakan justru adalah putusan-putusan pengadilan. Ya, putusan-putusan pengadilan, termasuk tadi ada konsep tentang equity, gimana ketika misalnya kontrak itu dibuat berat sebelah sifatnya gitu ya, secara tidak fair misalnya. Kemudian juga Prof. Liu juga menyatakan bahwa di Singapura itu mereka nggak punya peraturan perundang-undangan yang secara kodifikasi hukum kontrak tuh nggak ada gitu ya. Mereka nggak punya kayak kita misalnya undang-undang ITE mengatur tentang kontrak elektronik, undang-undang ini mengatur tentang kontrak ini gitu misalnya, tidak. Tetapi mereka sama seperti kita juga memiliki berbagai peraturan perundang-undangan yang bisa membatasi bagaimana kontrak dibuat ya. Misalnya undang-undang ketenaga kerjaan ya membatasi apa yang boleh dan nggak boleh misalnya dalam undang-undang, dalam kontrak kerja ya kan. Undang-undang perlindungan konsumen misalnya ya kan membatasi bagaimana kontrak bisa disalahgunakan oleh pelaku usaha yang merugikan konsumen misalnya ya kan. Tetapi mereka tidak memiliki apa namanya ketentuan undang-undang yang secara khusus mengatur tentang kontrak. Ya, kalau kita kan memiliki KUH Perdata ditambah lagi berbagai peraturan perundang-undangan lainnya ya yang mengatur tentang kontrak-kontrak yang spesifik gitu. Prof. Liu, please carry on.
Okay, thank you very much. So, as I just talked about, misrepresentation can be a big concern as well. And as I said, entire agreement clauses usually will not help with that. That's why there is this other kind of clause called a non-reliance clause. And in terms of how it's drafted, actually usually you see it combined together with the entire agreement clause as a single clause or maybe as sub-clauses of the same section. And this is a non-reliance clause is a clause that says basically that that the parties have not relied on any representation that was made in entering into the contract. Sometimes they go further and say that no representations were made. That's a little bit strange because it's very hard to imagine a contract that you negotiate without making any representations about. But sometimes the clause says that. But the important thing is that it states that the representations were not relied upon in entering into the contract. So here's an example of a non-reliance clause, also from an actual Singapore case. This is a contract between a bank and a customer who was using investment services with the bank. And I won't read the whole thing out, it's a little bit long, but basically the customer agrees in this clause that he made his own judgment in an own assessment in entering into any investments or other decisions that he makes. So basically, once this clause is there, if the court gives effect to it, then that will prevent the customer from saying, or the customer or the other party or whatever the party may be, from saying that, hey, you, the other party, made a representation to me and I relied on it, and by relying on it, I have suffered some loss. Because if they make that argument, then the other side is going to say, no, the contract says that you did not rely on any representations I made. The contract says you will make your own assessment, you have made your own judgment, and so you're contractually bound by that. And this is said to raise what we call an estoppel. Estoppel, which I think you might be familiar with, is basically anytime a party is prevented from making an argument or relying on something because of something else they've done. And here, the idea is that in the contract itself, a party has said that they didn't rely on any representations. So when they go to court, they are not allowed to contradict what they've agreed and now complain that the other party made a misrepresentation to them that they relied upon. So if the clause is given full effect, it's very powerful. There is an exception, which I'll talk about later, but it's not easy to satisfy the exception. I don't intend to talk about now because it's the same exception that applies to another kind of clause I'll talk about in the next section. But in a nutshell, that is what a non-reliance clause does. It stops a party from arguing that representations were made to it that it relied upon. And so that would knock out any misrepresentation claim that is made. Okay, maybe because that was a shorter and simpler section, maybe I'll cover the third type of clause before taking a pause for questions or clarification. These two clauses that I just talked about, entire agreement clauses and non-reliance clauses, are meant to sort of operate at the time of contracting to keep out things that have been said before, right? But what about things that are said as the contract continues? So after the parties have agreed, they still, I mean, some contracts are executed, right? You do it once and there's nothing else to do, like sale of a car, for example. But then other contracts have to continue being performed for some time, right? Like a license agreement or lease or things like that. In that context, parties may continue talking and they might agree other things. They might promise things or represent things. And so there's this concern that commercial parties may have that as the contract progresses in its performance, the certainty of what is written in the document may be lost. Parties worry that later on, the other side will say, hey, yes, we had this contract earlier, and this contract had an entire agreement clause and so on. But then later on, you told me over the phone that you want to change the contract, and I agreed, right? So then that introduces certain uncertainty. So one way that parties try to prevent this in advance in their contract drafting is to include something called a no oral modification or no oral variation clause. And that can be phrased in different ways, but in essence, it will say something like, all variations must be agreed and set out in writing and may be signed before they take effect. And the idea here is to allow both parties to later say, if the other side tries to say that there was an oral modification or variation, they can say, hold on, look at this clause. The clause says that only written variations will be effective. So I can just ignore what you're saying now, and the court should ignore what you're saying if you try to argue that there was some later modification that was not in writing. So this is, again, a pretty powerful clause. In the UK, it is given full effect. So unless, there's one exception. The exception is if a party has reasonably relied on the modification. So, for example, let's say there's no oral modification clause like the one I've got on the screen now. But then when the parties talk about it later on the phone, one of them says, yeah, I know that we have this clause, but it's really troublesome. We don't have time to sign, to write it out and sign. I'm telling you now, let's change it in this way. Are you okay with that? The other party says, yeah, I'm okay with that. And then they act on it to their detriment. In that situation, then the court might say that because one party has already reasonably relied on the understanding that the other party gave them, that they would recognize the oral modification as valid, then both parties are bound by that. So that's one exception. But outside of that limited exception, in the UK, so long as there's a no oral modification clause, the court will just block out any subsequent alleged attempt to modify the contract orally. In Singapore, it's a little bit different. We have considered the English position and actually rejected it quite recently, but it's still quite powerful. Basically, it raises a presumption that can be rebutted with evidence, a presumption that there is no variation or modification unless it's in writing. What that means is, if there's a clause like this, and you're in Singapore and you're trying to argue that despite this clause, there was still an oral modification, then you need to prove not just that there was the attempted modification, you need to prove that the parties intended to disregard or intended to get rid of the no oral modification clause. You need to prove that before you can rebut the presumption. So no oral modification clauses in UK are kind of like a magic bullet for this sort of argument outside of the exception. In Singapore, not a magic bullet, but still quite powerful and advantageous for the party seeking to exclude the oral modifications. Okay, so these are the three clauses, the three types of clause that parties introduce to try to keep their agreement to what is written in the four corners of the written contract. And you will often see these bundled together. And I would say that from my experience, I mean, I never was a contract negotiator. I have not been a transactional lawyer, but I have seen quite a lot of contracts that went to court in disputes subsequently. And I would say that at least in Singapore, it's more common to see these clauses than to not see them. They are kind of like just the boilerplate clauses that most commercial parties will always include. Entire agreement, non-reliance, no oral modification. Most contract lawyers will advise clients to just put them in because you want certainty. And so it's not necessarily either party trying to take advantage of the other. It is really usually trying to avoid disputes in future by keeping both parties to the bargain of what they have written down and nothing else. Okay, so this I think is a good point for me to take to pause for any questions and for summary, because the other clauses I'm going to talk about after this are quite different. So I hope this has been helpful, and I'll just pause here for a moment. Thank you.
Ya, oke, thank you, Prof. Liu. So, jadi sebelumnya tadi Prof. Liu ada menunjukkan contoh klausula non-reliance ya, you call it as the non-reliance clause, Prof. Liu ya. Jadi klausula non-reliance tadi ya. Jadi kan jangan lupa ya, ini kita topik besarnya hari ini adalah jenis-jenis klausula dalam kontrak, khususnya dalam perspektif common law gitu ya. Nah, jadi klausula non-reliance tadi juga biasanya ditemukan dalam kontrak-kontrak common law yang tujuannya adalah untuk menegaskan bahwa salah satu pihak itu memutuskan untuk berkontrak, ya kan, berdasarkan judgment-nya tanpa bergantung kepada representation tadi. Representation itu adalah hal-hal atau fakta-fakta yang tadi ya, yang diungkapkan adalah benar gitu ya oleh salah satu pihak. Yang tadi kita udah bahas ya, bahwa kalau yang namanya misrepresentation itu bisa mengakibatkan kontrak dibatalkan, atau misalnya kita mengajukan gugatan ganti rugi misalnya gitu ya. Tapi ketika di dalamnya dimasukkan klausula non-reliance tadi, itu berarti para pihak sepakat bahwa mereka mengambil keputusan untuk berkontrak itu berdasarkan keputusan dan penilaiannya sendiri gitu, tanpa menggantungkan kepada representation tadi. Dengan kata lain, konsekuensinya jika misalnya ternyata ada misrepresentation, dia nggak bisa menjadikan itu dasar untuk misalnya membatalkan kontrak gitu, atau apa namanya, untuk minta ganti rugi gitu, karena dia sudah menyatakan di awal dengan memasukkan klausula tadi bahwa dia berkontrak, sepakat untuk berkontrak dengan pertimbangan dan penilaiannya sendiri tanpa bergantung ya kepada klausula terhadap representation tadi misalnya. Nah, kemudian tadi juga di dalam penjelasan Prof. Liu tadi muncul ya konsep estopel ya, namanya konsep promissory estopel, itu tidak ada ya di dalam ranah hukum civil law, tidak ada ya, itu konsep common law ya. Estopel itu berarti ketika salah satu pihak itu dia berpegangan kepada satu janji yang diucapkan oleh salah satu oleh pihak mitra, oleh pihak lain gitu ya, meskipun janji tersebut nggak jelas atau mungkin masih ambigu, tapi ketika dia berpegangan pada janji tersebut ya kan, dan kemudian akibat dia berpegangan kepada janji tersebut meskipun secara lisan itu, dan di kemudian hari ternyata muncul kerugian akibat itu, maka dia keberlakuan janji tersebut dia sama kuatnya seperti sebuah kontrak. Jadi ketika janji tersebut dilanggar itu sama seperti melanggar kontrak, gitu ya. Kurang lebih seperti itu. Itu konsep kontrak, konsep common law. Terus kemudian no oral modification clause ini ya saya rasa ini cukup lebih sederhana gitu ya, bahwa dengan dimasukkan klausula ini gitu kan, itu sebenarnya untuk mencegah adanya kemungkinan kontrak itu diubah secara lisan gitu ya. Jadi seperti itu. Makanya kan diatur ya di dalam apa namanya, di dalam kontrak ya, ditulis dalam klausula ini bahwa kalau misalnya mau mengubah kontrak, memodifikasi kontrak hanya bisa tertulis, ya kan? Dan tidak boleh dan harus disepakati oleh para pihak secara tertulis dan ditandatangani, kurang lebih seperti itu. Tetapi kemudian Prof. Liu sudah menjelaskan juga pengecualiannya. Ya, tapi intinya dari penjelasan Prof. Liu kita bisa menangkap satu hal penting, bahwa ternyata kontrak lisan, perjanjian lisan itu juga sebenarnya dihormati, kan begitu ya. Ada yang namanya janji secara lisan. Nah, itu di dalam dunia common law itu perdebatannya lebih dinamis gitu ya. Banyak perdebatan-perdebatan yang lebih dinamis berkaitan dengan janji-janji yang diberikan secara lisan. Prof. Liu, there's actually a question in the chat room. But before I go to that, because the question is actually still relates to our previous discussion. So in Indonesia, we also acknowledge oral agreement, like oral promise. But the main question in this case would be, how do you prove? Like, do you actually need to prove in court that the promise was actually given if it's oral? And what is the burden of proof like to actually show that the oral promise was actually given, Prof. Liu?
Yeah, like Indonesia, we also recognize oral agreements, and proof can be challenging because it could, in the simplest example, just be the testimony of a person saying, this is what I said, this is what they said. In terms of how it is proven, if it ever has to go to trial, usually the way we do it is we do have cross-examination, which will allow the other party and the court to test someone's claims about what was said and what was not. And before that, there would have been a written affidavit where the person puts down their version of events, what they remember being told and what they remember saying. Usually, there will also be quite a lot of circumstantial evidence outside of this direct testimony, because, for instance, a party may have subsequently discussed their contract, the oral agreement, in text to the counterparty or to another party. Or maybe one party or both parties will have started to take steps toward performing the contract and then you may have all these indirect bits of evidence that can help to confirm or to rebut the assertions that each side is making about the contents of the contract. And as to the burden of proof will be on the, well, I don't want to get too deep into common law burden of proof, but the party bringing the claim has the legal burden overall of proving every element of their claim. So if they are bringing the claim for breach of contract, then they need to show that there was a contract. But then, having shown that, of course, the two parties may have a contest over exactly what terms are in the contract, and so maybe it's the defendant who wants to argue that there was this particular term in their oral contract, and the plaintiff says no, there wasn't any such term. There, because the defendant is trying to assert that there was this term there, that this was said and accepted, then they would bear the burden of proof on that particular point. But overall, the burden of proof is always the plaintiff's to bear by default.
Okay, Professor, I want to go back to the chat room for this one question. So from Rizky, Rizky was asking, so let's say a Singaporean lawyer, let's say someone from Singapore that does not adopt the principles of good faith, create contracts in a different country, let's say in Indonesia, who adopts the principles of good faith. So how will that work? That's pretty much the basic question. So I mean, of course, I can also elaborate with you on that, but maybe I would want to know your answer first to Rizky's question.
That's a really fascinating question. I think that as a starting point, this kind of difficulty is, at least in part, a difficulty of the substantive law, because the fact that Indonesian contract law, like most, or I think probably all civil law jurisdictions, contract law incorporates good faith just inherently. But Singapore and other common law jurisdictions, we have an idea of good faith, but it's something that parties have to bargain for and agree to put in. That is, I think, an obstacle on two levels. One is just in terms of knowing what the substantive foreign law is. That's always a challenge. So a Singaporean lawyer who has who either does transactions with Indonesian counterparties or who's involved in cross-border litigation or arbitration will have to do their homework and be aware that, oh, the legal position is different. And of course, that's why in cross-border disputes, you would always want to get an expert in that other kind of law that you're not that you are not trained in to advise as well. But apart from just knowing that there's a substantive legal difference, I think it also produces a difference in the mindset, because basically, even though common lawyers also know what good faith is, and we know that there are cases where a court has held that parties have bargained to incorporate a duty of good faith, or it can be implied on the very special facts of that case. We don't deal with it normally. So I think it leads to a mindset difference where a common lawyer reading a contract tends to take every clause to its extreme, at least in interpretation. So you always will tend to give it its most favorable to your client interpretation, and you expect that each party Of course, parties won't always enforce their full rights if they are in a healthy commercial relationship and they want it to succeed. But when things start going bad, at least you expect that each party will just go all the way in enforcing their strict legal rights. There's no idea of what I think. I don't know if you use this term in Indonesian law. I've seen it in other civil law jurisdictions. This idea of abuse of rights, which is related to good faith, that you may have the right legally, but it may be wrong to use it in a way that is excessively harmful to your counterparty, especially if it's not very beneficial to you. And in common law, we just don't have that. So there isn't this kind of restraint on how you use the rights you have. So it can sometimes lead to sort of, I think, sort of mentality differences. And I don't know any way to properly resolve that other than to really be aware when you're dealing with lawyers from other jurisdictions that the differences may go deeper than the substantive law. The differences in the substantive law may actually mean that the lawyer opposite from you has a different mindset. You need to understand what mindset they're coming from when you're negotiating, for instance. Very interesting question. Thank you. And I'm sure Dr. Detania has plenty to add to that.
Yeah, I think I can try to elaborate it like as simple as possible. Jadi intinya adalah sebenarnya bergantung sebenarnya maunya apa gitu ya. Tiap klien gitu ya, tiap pihak itu mungkin punya preferensi gitu ya. Jadi kalau misalnya ada mereka melakukan transaksi kemudian yang satu mungkin dari common law, yang satu dari civil law, kurang lebih begitu ya. Nah, jadi tentunya yang perlu ditanya, yang perlu dipastikan dulu maunya apa gitu ya. Apakah mau justru mengenyampingkan agar asas itikat baik itu tidak berlaku atau justru mau berlaku. Nah, itu kan makanya kan kebutuhannya berbeda gitu ya. Jadi kalau misalnya dan itu juga I think Prof Liu if please correct me if I'm wrong, also the choice of law clause in this case also matters, right? I mean, if the choice of law, let's say, is the Indonesian law, so the principles of good faith would apply automatically, right? So it means that if you want to stop that from happening, of course, you would choose something else as your choice of law, right? Okay. So, jadi itu juga akan bergantung kepada kebutuhan para pihak, gitu ya. Jadi kalau misalnya nanti ada klausula pilihan hukum, kalau klausula pilihan hukumnya adalah hukum Indonesia, itu kan udah otomatis akan berlaku konsep itikat baik tadi karena hukum Indonesia berlaku seperti itu. Tapi kalau misalnya ternyata klausula pilihan hukumnya itu adalah hukum Singapura yang memang dibolehkan berdasarkan kebebasan berkontrak, yang berlaku adalah hukum kontrak Singapura gitu ya. Nah, itu yang kita harus perjelas dulu. Itu kan akan tergantung kepada preferensi para pihak. Tetapi intinya adalah memang itu menjadi satu tantangan yang besar ya di dalam dalam proses kontrak drafting ketika para pihak itu berasal dari dua sistem hukum yang berbeda dan memiliki mindset yang nggak sama gitu ya kan. Makanya itu menjadi tantangan yang lebih besar untuk memastikan ya tentunya kalau kita dari sisi mewakili kepentingan seorang klien ya untuk memastikan bahwa kebutuhan tadi terakomodasi kan kurang lebih seperti itu, kebutuhan tadi terakomodasi terlepas apakah mau dengan keberlakuan asas itikat baik maupun tidak gitu ya. Nah jadi kalau saya boleh langsung menjawab pertanyaan Kevin ya Zahran ya karena ini berkaitan supaya kita nggak terus-terus kembali ke asas itikat baik gitu ya. Nah, apakah artinya pihak-pihak dalam kontrak tidak selalu harus bertindak dengan itikat baik? Bukan begitu, Zahran. Konsep itikat baik ini sesuatu yang sifatnya bukan kita bisa diukur bahwa baik atau benar, bukan begitu ya. Dia konsep yang lebih fundamental begitu ya. Konsep yang fundamental tadi itu dia mengacu kepada tadi ya, bagaimana menafsirkan suatu peristiwa gitu ya, nah, yang mempengaruhi kontrak. Jadi bukan bertindak tidak beritikat baik itu bahwa harus kita maknai secara ini ya baik dan buruk, bukan begitu ya. Tapi intinya keberlakuan konsep itikat baik itu dia adalah bagaimana memaknai bahasa-bahasa dalam kontrak ini gitu. Ya kan, ketika ada kontrak tertulis, kemudian ada peristiwa-peristiwa lain di luar kontrak, misalnya. Ya, nah jadi intinya adalah setiap sistem hukum itu punya kekurangan masing-masing, ya, ada kelebihan dan kekurangannya masing-masing. Jadi tergantung para pihak ini maunya apa gitu. Misalnya kayak tadi saya kasih gambaran, kalau misalnya mau prinsip itikat baik ini berlaku, ya kalau dia di Indonesia otomatis berlaku. Tapi kalau misalnya ini adalah kontrak basis internasional, masukkan klausul pilihan hukumnya hukum Indonesia. Tapi kalau justru menurut para pihak itu bisa merugikan, kenapa? Karena asas itikat baik itu memungkinkan untuk menafsirkan peristiwa-peristiwa lain di luar kontrak sebagai bagian daripada kontrak, ya. Itu kan jadinya terlalu liar. Nah, jadinya mereka bisa aja memilih pilihan hukumnya bukan pilihan hukum Indonesia. Misalnya pilihan hukum Singapura. Jadi dengan kata lain, prinsip itikat baiknya juga tidak berlaku. Nah, belum lagi nanti kalau kita bicara soal penyelesaian sengketa, sengketanya ada di mana nih? Nah, pengadilan di Indonesia kah atau berarbitrase gitu ya? Apakah berarbitrase di dalam negeri ataupun di luar negeri? Nah, itu juga semuanya akan saling berkait ya, satu dengan yang lainnya gitu. Jadi biasanya kalau pilihan hukumnya adalah pilihan hukum asing, karena kita memang mau membatasi hal-hal yang memang kita tidak mau berlaku, maka itu juga pasti akan mempengaruhi pilihan forumnya nanti misalnya. Mungkin Prof. Leo akan sampai ke sana. Prof. Leo, please carry on. Sorry if it took too long to.
Oh, no, not at all. Not at all. Thank you so much. And actually, let me just build on that because I think you raised a really good point. Choice of law is really important. And I didn't cover it in this week's slides because I intended to touch on it next week, but it's absolutely crucial because, of course, if you are negotiating for your client and you want to get the protections that you are used to, then of course, the way to get around all this is you have choice of law, Indonesian law, as the substantive law of the contract. But of course, sometimes parties may not want that, especially in international contracts. And occasionally you might see, and most people who practice will have seen, contracts where the substantive law of the contract is actually not the law of either of the parties, of either of the parties' countries, because they wanted some sort of somewhat neutral substantive law, which can be a bit strange. So, if you're in a situation where your client cannot, where the parties cannot agree on Indonesian law, for instance, then one thing to consider doing is to make sure there is a good faith clause. If it's going to be governed by Singapore law or English law or some other common law, you can get some of that effect by putting in a clause importing an obligation to act in and to perform the contract in and to interpret the contract in good faith. And if it's there, then a common law court will give effect to that. And I think the concepts and the positions then become quite similar. It's just that you need to bargain for it. It's not a default rule.
Okay, so that also answers Kevin Zahran's question ya in chat room ya. Jadi Kevin, kalau ini adalah jurisdiksi common law, tapi para pihaknya sepakat memasukkan klausula itikat baik, itu berlaku gitu. Ya, mereka sepakat. Jadi hakimnya pun harus menafsirkan kontraknya dengan pendekatan itikat baik ya, konsep prinsip itikat baik. Tapi kalau tidak dimasukkan ke dalam kontrak, maka dia tidak otomatis berlaku, kurang lebih begitu. Ya, okay, please carry on, Professor.
Thank you very much. Okay, so now this brings me to the second half of my planned lecture. Of course, I know we only have about 20 minutes left, so I'll see what I can skip over or see if there's stuff I should reserve for the next class. But basically, these other clauses I'm going to cover are a bit different from the ones before. These are clauses that kind of modify or how should I put it? They are there to deal with situations that may arise later, rather than trying to keep terms and representations out of the contract. So the first is an exclusion or limitation clause. That's a clause that limits or sometimes completely negates a party's liability for a particular loss or particular kind of harm. And yeah, sorry, I got the slides out of order. Let me see. Yes, so I'm going to talk about limitation clauses, liquidated damages clauses. If I have time, I'll talk about force majeure clauses. And then, of course, dispute resolution clauses are actually also another kind of clause that is meant to address a specific situation. But it's so important that I've decided to leave that for the next class. So an exclusion clause can be phrased in many ways. This is quite a long exclusion clause, but basically it's saying that if any liability regarding the thing stated here shall be limited to payment of a sum specified in clauses that I haven't reproduced here, and not exceeding £10,000 for 12 months, right? So this is a summary of this clause. So it's setting a cap on how much liability a party can have to the other. And these clauses will generally be given effect to, subject to two controls. One control is that when interpreting an exclusion or limitation of liability clause, courts will be careful to make sure that the kind of liability that arose in the case before it actually is caught by, it actually falls within the terms of the clause. And the more extreme the clause is, and the more unfavorable the clause is to one party, the more vigilant the court will be in interpreting that clause. And it's been said that when, and this engages another rule, which I don't want to talk about in detail, but it's called the contra proferentum rule. Contra proferentum rule means you interpret a clause in favor of, against the party that introduced it to their advantage. So for instance, if you have an exclusion clause which excludes or limits a lot of liability, then a court will interpret that very, very narrowly as it can. So for example, I'll give you an extreme example. Let's say the contract says party A shall not be liable to party B for any loss arising, and there's no qualification. Then a court is going to look at such a broad and kind of ridiculous clause and read in a bunch of limitations, like, oh well, it can't have been intended to cover intentional breach, or it can't have been intended to cover negligence, for instance, because that is very extreme and surprising, and you would expect the parties to have specifically spelled it out, right? So that's one of the mechanisms courts use to control this sort of clause, by reading them very narrowly where possible. So the lesson for the contract drafter, if you are ever drafting a contract and you want to include such a clause, and well, I obviously I have no idea how they approach under Indonesian law, but let's say this is a common law governed contract. It's important to be clear with the language. So if you want to exclude a particular kind of liability, like you want to exclude negligence liability, then you have to very clearly say that you're excluding negligence liability, for example. So that's one way the court controls the power of these clauses. The other way it controls it is to subject them to the Unfair Contract Terms Act, which is originally an English act. It is part of Singapore law as well. It's quite complicated, but to put it very briefly, the UCTA, or ACTA as we call it, has three main effects. One is that you simply cannot exclude or limit liability for death or personal injury. And that's sort of a public policy position that Parliament has taken, that you just don't want people to be able to contract and say, I'm not liable for causing death, right? You can exclude other kinds of negligence liability, but only if the clause passes the reasonableness test, which I'll talk about in a bit. You can also exclude or limit other kinds of contract liability if it's a consumer contract or a contract on the breaching party standard terms. Then this clause also has to pass the reasonableness test. There's actually quite a lot of controversy over who exactly counts as a consumer, what exactly counts as contracting on the other party standard terms. But that's a whole class in itself. I can't touch on this, and it probably wouldn't be useful to you. But I think the simplified version is just that. The UCTA allows the court to subject some kinds of contract to scrutiny under this reasonableness test. And the reasonableness test asks whether, it's a bit of a long sentence there, but basically, is it reasonable to have this clause in this contract? And that is assessed at the time the contract was made, disregarding whatever happened after. So the court will look at the limitation clause and ask, in the context of the transaction, was it reasonable to include this clause? And that sounds very broad, but the statute also provides a list of factors which the court is supposed to consider. The factors include differences in bargaining power. So if one party has much more bargaining power, such that the other party couldn't really say no, then it is more likely that the clause is not reasonable. Another factor is whether the party had an opportunity to contract with others without accepting such a term. Again, if there was no such opportunity, then that is a factor pointing toward the clause being unreasonable. So, for example, if you think about a contract with your cell phone coverage provider, where whether you go to company A or company B or company C, they're all going to make you sign essentially the same kind of contract with them. Then it can't really be said that you had an opportunity to contract with other parties that would not have included such a term. And if you don't have that opportunity, then again, it's less likely to be reasonable. And then, very important, another factor is whether the plaintiff knew or ought to have known that the term was in the contract. And so this might require the court to look at things like, well, how unusual is this contract? Does it depart from what you would normally expect in a contract of this type? The court might also look at the length of the contract. If you've got like a 200-page document, and somewhere in these 200 pages, there's this exclusion clause, then that is less likely to be reasonable, because it's hard to say the plaintiff knew or ought to have known the term was there. Whereas if you've got a contract which is just one printed page, then it might be very fair to say that, well, it's just one page. Everyone should have read it and known that the term was there, and if they didn't like it, they could say no. Right? And there are other factors as well, but basically, it's quite a holistic exercise. And in the situations where it applies, because as I said, not every contract is subject to ACTA, but where it applies, it is quite a powerful tool that courts can use to limit the effect of exclusion or limitation clauses, which it thinks are too extreme and unfair.
Yeah.
Okay, and the last thing I'll say about this is that this provision of the ACTA also can apply to non-reliance clauses, because this is on the basis that, well, if the court looks to substance rather than form, non-reliance clauses often, in effect, exclude or limit liability, because by invoking the non-reliance clause, a party is saying, I am not responsible for any losses caused by my representations to you. That's one way to view such a clause. And if the court takes that view, then it could, on that basis, apply ACTA and ask, well, was this non-reliance clause reasonable to include in the contract or not? Okay, so that's it. But I just want to end this part of the discussion with the cautionary note that ACTA does not apply to all contracts. It's just that it's a bit too complicated for me to tell you in detail what kind of contracts it will apply to and what kind of contracts it won't apply to. But it is there, and it is one way the court can control excessively broad and powerful exclusion and limitation clauses. Okay, so maybe I should pause here because it's quite a lot.
Ya, thank you, Prof. Liu. Jadi tadi Prof. Liu menjelaskan tentang keberlakuan jenis klausula exclusion ya, atau kita sebut juga dengan klausula eksonerasi ya. Klausula eksonerasi atau exclusion clause ini biasanya klausula yang berupaya untuk membatasi tanggung jawab hukum gitu ya. Biasanya kalau dalam konteks hukum Indonesia gitu ya, keberlakuan klausula eksonerasi ini dibatasi dalam Undang-Undang Perlindungan Konsumen gitu ya. Jadi sama juga seperti di Singapura bahwa klausula seperti ini dia tidak berlaku mutlak gitu ya. Jadi juga ada ketentuan-ketentuan hukum seperti tadi ya, ada Unfair Contract Act gitu ya. Jadi undang-undang yang mengatur tentang kontrak-kontrak yang istilahnya nggak adil gitu ya, yang yang bisa membatasi gitu ya, klausula-klausula yang istilahnya merugikan gitu ya. Itu juga membatasi keberlakuan klausula-klausula seperti ini gitu ya, exclusion atau limitation clause ini gitu. Nah, terus kemudian tadi juga Prof. Liu ada menjelaskan bahwa dalam konteks common law, khususnya dalam konteks hukum Singapura gitu ya, mereka untuk menilai apakah sebuah klausula pembatasan ini atau klausula exclusion ini berlaku atau tidak, mengikat atau tidak, mereka punya konsep namanya reasonable test gitu ya. Ya, dites apakah memenuhi kriteria-kriteria gitu kan untuk bisa dikatakan bahwa itu klausulanya mengikat atau tidak. Jadi memang tentunya nggak semuanya bisa kita jelaskan secara detail di sini gitu. Tapi intinya sebenarnya ada kemiripan juga ya dengan hukum Indonesia bahwa klausula seperti ini dia tidak berlaku mutlak ya. Seperti misalnya dalam konteks hukum Indonesia di Undang-Undang Perlindungan Konsumen itu menyatakan klausula yang mengalihkan tanggung jawab gitu kan pelaku usaha itu sifatnya kan batal demi hukum. Nah, kurang lebih seperti itu gitu ya. Tetapi mereka istilahnya mereka punya ya tadi ya tes tadi gitu ya, reasonable test tadi gitu, lebih lanjut gitu. Nah, kemudian ada pertanyaan pertama dari Rizky. Saya langsung jawab ya Rizky ya, karena tadi sebenarnya udah dijawab sama bukan dari Rizky, dari Rangga gitu ya, in the chat room ya, berkaitan dengan kekuatan perjanjian lisan. Tadi sebenarnya sudah dijawab sama Prof. Liu, karena jadi itu akan menggunakan alat-alat bukti yang lain ya, seperti kesaksian gitu ya. Tadi udah dijawab oleh Prof. Liu gitu ya. Terus kemudian Prof. Liu, if you allow me, maybe we can also start with the questions in the chat room. Ada pertanyaan dari Rizky. This is exactly the same question that I had in mind ya. Prof. Liu, so basically what Rizky is asking in the chat room is that is it possible to include a penalty clause? Yeah, let's say in payment delay, for example. And then maybe you can wrap it up at the same time because we have limited time. So that would be the first question. Will it be possible to include a penalty clause for any kind of maybe contract defaults, yeah, something like that, or delay in payment, yeah. And then the next question is from Ade would be, how, in your perspective, how do you decide which law is applicable in cases when a transaction involves two or more jurisdictions? I think that would be the main question from that. And then the next one would be, so what comes after the invalidation of a contract? I think it relates to damages, the questions about damages after the invalidation of a contract or rescinding a contract. So what comes after? So do you need to, let's say, file another lawsuit for damages, or will it work automatically after the invalidation, for example? And then last but not least, okay, I think for the last question, I will elaborate myself personally, because I think in your explanation before, you have mentioned about it. So I will elaborate on it in the end. So maybe you can focus on the three questions. Yes.
Sure. Thank you very much. Sorry, but could I just check, Dr. Detania, how I note that originally we're supposed to end at 10:10, which is coming up soon. So could I ask how much time I have left to answer these questions?
So yes, we usually end at in 2 minutes time. That's why to wrap the questions.
Okay. So
we can everything.
okay.
In maybe 5 minutes. I think we can have like
okay.
two, which is
Great.
fine.
Okay, thank you. I think I can do that in 5 minutes. So let me start with the choice of law question. When you have a cross-border transaction with multiple jurisdictions, how do you decide which one applies? The simple answer is, well, if you have that kind of complex deal, you will always negotiate for what law applies. So the contract should always say this transaction will be governed by the law of whatever state, right? Whatever country. But then in the very unfortunate situation where somehow there is no clause, there's no choice of law clause in that contract, then it will depend on the choice of law rules of the court that is hearing the case. Every country has its own choice of law rules. In Singapore, our court, if it was hearing a case with multiple jurisdictions and no express choice of law clause, then it would look for the law of closest connection to the contract or to the transaction. It might look at things like where are people located, where was it going to be performed, all that stuff. But that's just Singapore conflict of laws. Every country has its own. And that's exactly why when you are a deals lawyer, you must always make sure that there is a choice of law clause in there. Otherwise, there's so much uncertainty. Okay, then turning to the damages question, in common law countries, you don't need to file a separate lawsuit for damages. If you're seeking to invalidate the contract, then as part of the relief, part of the prayer to the court that you're asking for, you would also include your claim for damages. So you would say something like, I was misrepresented to because the misrepresentation induced me to enter the contract. I asked the court to declare the contract to be void or to be rescinded, whatever it is. Also, this has caused me loss of however much money, and I asked the court to award damages to me, right? So you would do it in the same proceedings. You would not have a separate suit after the contract has been invalidated. Finally, on the penalty clause question, this is actually what I was going to cover next, but I'm going to give a very, very brief version of this. In short, yes, you can have liquidated damages clause. I wouldn't call it a penalty clause. And that's a clause that says, if you breach, for instance, you default or you're late or whatever, you have to pay X dollars, right? Liquidated damages. In common law, we would avoid the term penalty clause because there is this rule against penalties. So you can have a liquidated damages clause, but it cannot amount to a penalty. And there are two tests that courts can apply. In Singapore, we use a pretty old common law test called the Dunlop test. And the question is whether the sum is a genuine pre-estimate of loss, meaning whatever sum is in the liquidated damages clause, is that kind of like a good guess or good estimate of what the loss was going to be. So basically, the court is happy to enforce it if it seems like the parties put that figure down because that is an estimate of what the loss would be likely to be. And there are these factors that the court looks at. But if it is in excess of that, if it is like something meant to punish someone for breaching, then the court will hold that that is a penalty. And if it's a penalty, then it's not enforceable under common law. In the UK, and maybe some other common law jurisdictions, I'm not too sure, there's a more recent test. Singapore doesn't use it, but the UK does. Instead of asking whether it's a genuine pre-estimate of loss, they ask whether the sum specified is disproportionate to the legitimate interest in performance. So in other words, if I have a contract with you and it says, if you pay me late, you have to pay me an additional however much money, then the court will ask, okay, but what's my legitimate interest in getting timely payment? And is the sum that I make you pay if you're late disproportionate to my legitimate interest in ensuring timely payment? If it's disproportionate, then it's a penalty. If it's not disproportionate, then it's okay. It's a liquidated damages clause and it can be enforced. Yeah, so I hope that answers the question. And I think that's probably all the time I have. I will hold over my last point till the next lecture. Thank you very much.
Thank you, Prof. Liu. We actually have more questions coming in, but I will save the questions from Gabriel, including the one from Hamdi, for our discussion next week. I would like to thank you for your time today, and also to Ibu Dr. Sharifalisa and all the students for our very interesting and fruitful class and discussion. Thank you, Prof. Liu. So I think we can wrap the class for today, and we'll see, hopefully we can see you again next week at the same time. Thank you. Have a good day, Prof. Liu.
You too. It's been a pleasure.
Thank you, Prof. Liu. Thank you, Bu Deta.